You know, in any high-stakes game, those first few moves can literally decide the whole thing. And believe it or not, the legal world is exactly the same. So today, we're going to break down the critical first moves of a lawsuit.
Come on, we've all heard it, right? In movies, on TV shows, someone gets mad and yells, "I'll sue you." But have you ever really stopped to think about what happens next? What does it actually take to get that legal battle started? I'll give you a hint, it's a whole lot more than just storming into a courtroom.
The best way to think about a lawsuit is like a high-stakes chess match. Seriously, your opening moves, we're talking about the procedures you file, the papers you file, they are everything. Make one wrong move, miss one little procedural detail, and bam, you could be in checkmate before you've even had a chance to really play. Okay, so where do we even begin? Well, before a single piece of paper is filed, you need something much more than just being angry or feeling wronged. You can't just sue someone because you're upset. The law has to actually recognize your reason for suing. And that reason has a name. It's called a cause of action. It sounds kind of technical, but all it really means is the specific thing that went wrong. It's the moment when someone's action, or maybe their failure to act, violated your legal rights. If you don't have a valid cause of action, well, you don't have a case. It's that simple. Now, this is where it starts to get really strategic. See, one single incident, one cause of action, can actually lead to a bunch of different claims. Let's say you're in a car accident caused by a reckless driver. That one event could let you sue for actual damages, for your hospital bills and car repairs, but you could also claim moral damages for the pain and suffering, and maybe even exemplary damages, which are basically designed to punish the other driver for being so reckless. Okay, so you've got your cause of action. You know why you're suing. Your next move is just as critical, maybe even more so. You have to pick the right battlefield. And nope, you can't just file your lawsuit in any court you feel like. So how do you figure out where to file? It really just comes down to answering two big questions. First up, jurisdiction. This is all about the court's power to even hear your case. You've got to pick the right level of court, and that usually depends on what the case is about or how much money is on the line. Then you have step two, venue. This is way simpler. It's just about the location. If your lawsuit is about a piece of land, you'll probably file where the land is. If it's something more personal, it's usually where you or the other person live. And here's a huge rule you can't forget. You have to start at the bottom. There's this thing called the doctrine of hierarchy of courts, which basically means you start at the lowest possible level. You can't just jump straight to the Supreme Court. If you try to skip the line, guess what? Your case is getting tossed right back down the ladder. All right, so you've got your reason, you've picked the right court, now it's time to make it official. It's time to fire the opening shot of the legal battle, filing the complaint. And listen, to get in the game, you literally have to pay to play. This is a step you just cannot skip. The court doesn't officially have any power, any jurisdiction over your case until you file that complaint and pay the required court fees. They're called docket fees. It's simple, no payment, no lawsuit. Now, along with that complaint, there's another super important document you have to file. It's a sworn statement where you basically promise the court you're not forum shopping. And what's that? It's trying to game the system by filing the exact same lawsuit in a bunch of different courts, just hoping one of them gives you the answer you want. Okay, pay attention here, because this is a big one. There are two sworn statements, and you have to know the difference. The verification is where you swear all the facts in your complaint are true. If you make a little mistake here, it's often fixable. But the certification against forum shopping, that's you swearing this is the only time you filed this case. If you mess this one up, it's a fatal error, not curable. The case gets dismissed, end of story. So, your case is filed. The fees are paid, the court has it. What's next? Well, now you have to let the other person know they're being sued. And this isn't just being polite, it's a fundamental constitutional requirement. This official notice is called a summons, and getting it delivered correctly is absolutely critical. It's the cornerstone of what we call due process. Everyone's right to have their day in court. If you don't deliver that summons the right way, the court never actually gets power over the defendant, and the whole case could be thrown out, declared totally void. But what happens if the person you're suing is, hiding or dodging you? Well, you can't just give up. The rules are super strict on this. You have to make a real effort. We're talking at least 3 separate attempts on 2 different days. Only if all of those fail can you use what's called substituted service, which means leaving the summons with a responsible person at their home or their office. Okay, the summons is served. The opponent has been notified. The ball is now officially in their court. They have a clock ticking and a limited amount of time to make their next move. So, what happens if you're the one being sued and you just ignore it? It's a tempting idea, right? Maybe if you just pretend it's not real, it'll all go away. Let me tell you, that is the single worst strategy you could possibly have.
Because if you miss that deadline to respond, the person suing you can ask the court to declare you in default. Think of it as forfeiting the game. It's a massive win for the plaintiff because you've just lost your right to fight back. They get to present their evidence completely unopposed. And just like that, the opening moves are done. The complaint is in, the right court has been chosen, your opponent has been notified, and they've either responded or they haven't. The chessboard is officially set. And now, the really strategic part of the game is about to begin. So, after hearing all that, what do you think? What's the most powerful opening move in a lawsuit? Is it having that perfect, undeniable cause of action? Picking just the right court? Or maybe it's making sure that summons is delivered flawlessly? It really makes you think, doesn't it? The real game, the real strategy, it all happens long before anyone ever steps foot inside that courtroom.